Hello, my name is Ed Cross. You know, the biggest problem in the property restoration industry today is getting paid. I'm an attorney in California, Texas, and Hawaii, and I help restoration contractors get paid. This video is general information and is not intended to be legal advice. This is not to condone any particular price method. Every restoration contractor needs to come up with its own prices independently. The Aliso Viejo case against Allstate was for sums charged for contents restoration work on a large residential fire claim in Southern California. The primary issue in the case is whether or not my client, the general contractor, was entitled to overhead and profit for subbed out contents work. Allstate sent a series of emails to my client saying, Allstate does not cover overhead and profit for mitigation and contents, which was interesting because it had already paid overhead and profit for mitigation on that claim. We sued for insurance bad faith, attorney's fees, and interest. And Allstate ended up paying my client $335,000 to settle a dispute over a $33,000 invoice. What is insurance bad faith? Well, the law implies in every kind of contract, including insurance policies, a promise to act fairly and in good faith. This requires the insurance company to refrain from doing anything that would impair the rights of the policyholder to receive the benefits under the policy. The bottom line is insurance companies need to act reasonably. When they unreasonably withhold or delay a payment, it subjects the insurance company to liability for bad faith in most states. To fulfill its implied obligation, the insurance company has to give at least as much consideration to the interests of the policyholder as it gives to the interests of the insurance company. In other words, the insurance company is not allowed to simply focus on facts that would support a denial of the claim and ignore facts supporting payment of the claim. The insurance company has to look at all of the facts, and in ambiguous cases as to whether or not the policy affords coverage or not, the item is covered. In other words, the insurance company has to err on the side of coverage. An extremely important point for restoration contractors is that an insurance company cannot deny payment for restoration charges without fully investigating the grounds that would support a denial. I became interested in the Aliso Viejo case because my client told me that Allstate didn't ask my client what efforts it engaged in to try to coordinate the contents portion of the job. It seemed to just disregard the fact that my client coordinated many different trades on the job. Now, although contents is arguably not a construction trade per se, it is nonetheless a very important component of a restoration project. You may have fragile items, highly valuable items, items with sentimental value, items that can't be easily cleaned. Arguably, a contents restoration project is more complex than a structural restoration project. Our view is that contents should not be viewed in some sort of a vacuum as if it were a single trade in an effort to deny overhead and profit. I call that bad faith splintering. In this case, our expert's opinion was that if one entity oversees and coordinates an entire project, all the trades should be considered for purposes of overhead and profit, even if one is not traditionally considered a construction trade. It was also very important here that the homeowner hired my client to quarterback the entire job, and that fact was communicated over to Allstate. The most important evidence to support a case like this is emails from insurance adjusters. And here the emails from the insurance adjusters indicated that Allstate was not even going to consider overhead and profit for contents. And we felt that supported the claim for insurance bad faith because they were making blanket statements about overhead and profit. Another very important type of evidence in this sort of case is oral deposition testimony of insurance adjusters. I took the depositions of several different insurance claims professionals in this case. California law allows a party to spend 7 hours taking the deposition of a single witness. Interestingly, Allstate aborted my deposition of its claims supervisor only 3.5 hours through it and refused to allow me to continue. I had to go to court and file a motion to compel that claims supervisor to appear for a deposition. Allstate went to court to get an order preventing me from sharing the videotaped depositions of its insurance adjusters. Unfortunately, that order was granted. But that order does not apply to the deposition of our expert, Jeff Taxier, who retired from Allstate's claims department after 35 years. For the last 7 years he was with Allstate, he was the claims manager of its Southern California property claims unit. Mr. Taxier testified that my client was entitled to overhead and profit for the contents portion of this job, partly due to the level of coordination that was involved. Mr. Taxier testified that my client, the contractor, was entitled to overhead and profit. Allstate took the position that my client didn't really spend much time coordinating the contents portion of the job and didn't have any records showing the specific amount of time that it spent on that coordination. Jeff Taxier was asked what my client did to coordinate the contents portion of the job, and here's how he testified.
Based on what you've read, do you have an understanding as to whether did anything to coordinate the contents portion of the claim?
Yes.
And what is your understanding?
Well, everything from the initial walkthrough of the loss to identifying what could and could not be done on site to making the decision that a third party was warranted based on the scope size of the loss. Based on locating and identifying a vendor who they felt was qualified and capable of doing the work, of arranging to meet them at the loss site. He met with them at least 5 times out at the loss site, and that doesn't seem out of the ordinary for the size of this loss. Part of it's because they have to coordinate all of this work along with the cleaning and the items in the pods and the reconstruction and repair work at the house as well. So there was a lot of coordination from what I could review in the file. The amount that would be owed is the amount reasonably necessary to, pay for a covered loss. So.
Okay, and is the amount reasonably necessary to be paid for a covered loss to be determined on a case-by-case basis?
Yes, as there is a specific claim, and that would be what the payment would be based on. I know some contractors in California that believe and do charge for overhead and profit on every job they do because their opinion is that they still have the same overhead and the same expenses and the same amount of profit that they need to make on each and every job. So that's what they choose to do. That's their business model. For me to say whether that's a good business model or not, it's their business model.
Okay, my focus isn't so much on the business model that you described. My question is about whether overhead and profit should be paid. And would you agree that whether overhead and profit should be paid on a portion of the claim is dependent on the amount of coordination that the general contractor does for that portion of the claim?
And I thought I said the answer to that was no. There may be a lot of circumstances involved in the charging of overhead and profit. Coordination may or may not be one of them.
Do you think coordination is a factor that should usually be taken into account in determining whether overhead and profit should be paid?
Not necessarily, no.
Do you think the complexity of the job is a factor that should be taken into account in determining whether overhead and profit should be paid?
Yes, I do.
And do you believe that the complexity of the job should be determined by how many trades are needed?
No, I do not. If the contents contractor is working for the general contractor, not working directly for the insurer, and the general contractor is doing other work on the job for the insured, then I would expect that the general contractor would charge overhead and profit on the contents portion of the work.
I understand that you would expect the general contractor to charge overhead and profit. Again, my question isn't whether the general contractor is going to charge it. My question is, the general contractor hires a content specialist to do the contents portion of the claim and does nothing more than pick up the phone and call the content specialist. Do you think the general contractor is entitled to overhead and profit on that contents portion of the claim?
And the same answer. I think you've asked it like 3 or 4 times, and I think I've given you the same answer. I really don't know what else to say, Mr.
Mr. Taxier, you have given me an answer, but you keep changing the question, and I don't mean that disrespectfully. You kept saying at least twice you expect the general contractor to charge overhead and profit, right?
Yes.
My question is not whether you expect the general contractor to charge it. My question is focused on whether the general contractor is entitled to be paid overhead profit. Did you see the distinction I'm getting at?
Well, if they charge for it and that contents contractor is working for the general contractor, then yes, I would expect them to charge and get paid for it.
So in your experience, every time a general contractor hires a subcontractor to work on a contents portion of the claim, so long as the content specialist is working as a subcontractor, regardless of the level of coordination or time and effort that the general contractor puts into the contents portion of the claim, the general contractor should be paid overhead profit on the contents portion of the claim.
Again, I think we're going ring around the mulberry bush here, but in a situation in which the general contractor is responsible for a variety of different things, such as construction, repairs, cleaning, whatever you want to call it, and for the contents, with the insured's permission, they make the decision that they want to hire somebody else working for them, not working for the named insured, certainly not working for the insurance company, to do that work. Then I'm of the opinion that that general contractor is entitled to charge overhead and profit as well as be paid for it. I'm also not aware of anything in the insurance policy that says anything about coordination, just like it doesn't say anything about overhead and profit.
It's difficult for an insurance company to refute that many facts, but just because an insurer makes a mistake handling a claim does not necessarily make it liable for insurance bad faith. The plaintiff in a bad faith case has to prove that the insurance company acted unreasonably. And here's how Mr. Taxier testified on that.
My opinion is that Allstate's claim handling of this loss was certainly not up to the standards that I would have expected Allstate based on the time that I worked at Allstate, based on my experience as a coordinator for property training at Allstate's home office, and certainly not based on the time that I spent as a property claim manager for Allstate. There were huge gaps that I saw in the handling of the loss that I could not find explained. And then there are a variety of emails from, even from maybe a structure adjuster that was covering for him at some point in time, which I thought were unprofessional and certainly not within what I would have trained them or expected them to be trained on how to respond to invoices for which they had a disagreement with the insured and or with the contractor acting on behalf of the insured. Direct statements, this is not a negotiation. We just don't pay for this. If you don't like what I'm saying, take it up with Allstate home office or something to that effect. All of that is definitely not good faith claim handling. Doesn't appear to be a whole lot of, actually almost no attempt with the adjuster to resolve this issue. Mr. did not create any estimates of his own. I don't see any evidence where he did an independent scope or an independent estimate on this loss.
Is it your opinion that Allstate breached the insurance policy in this case?
Yes, because I don't think that they paid what was actually and necessarily owed on the loss.
And is that an opinion you plan to offer in trial if called as a witness that Allstate breached the insurance contract?
Yes, it is.
When you say that Allstate didn't pay what was actually necessarily owed on the loss, are you referring to the dispute over overhead and profit?
That's part of it.
So is it your opinion that this was entitled to be paid overhead and profit?
Yes. In my opinion, was acting as the general contractor for a variety of different work done on this job. They had a contract to handle the structure, the restoration, the contents, cleaning, everything. And it's their general practice, as far as I could tell, charge overhead and profit as part of their invoicing on these types of losses. I see no reason why it shouldn't be paid.
Do you plan to offer the opinion that Allstate committed bad faith in this case?
Yes, in my opinion, they did.
And you plan to offer that opinion at trial if called as a witness?
Yes, I am. Allstate did not handle this loss appropriately, and it most likely owes not only the damages that are being asked for in the litigation, but additional costs associated with lawsuits of this type.
I tried hard to avoid a lawsuit in this case. I sent a demand letter to Allstate upfront saying, look, just pay the invoice and we'll go away. Allstate told us to pound sand and ended up paying us $335,000 to settle a dispute over a $33,000 invoice. Now, this case did not go to trial. This is not case law. The result is not legal precedent that's binding on other courts, but it is a good illustration that can be used in settlement negotiations. So here are the takeaways. First, it's easier to get paid when you have detailed records of who did what on your job and how long each significant task took. 2, every adjuster should understand that general contractors mark up the charges of their subs. Number 3, adjusters should not deny charges without thoroughly investigating them, giving at least as much consideration to the interests of the policyholder as it gives to the interests of the insurance company. 4, insurance companies violate the duty to investigate if they rush to judgment or they categorically assume that certain charges are not going to be covered, unless, of course, the policy expressly excludes them. 5, if there's no exclusion, the insurance company violates the duty if they make blanket statements like, we don't pay for that. 6, insurance policies do not exclude overhead and profit. 7, results of the insurance company's investigation should be documented by the adjuster. Grounds for the denial should be stated in detail in writing with reference to the applicable policy language. There are severe legal consequences if insurance companies don't act in good faith, and it includes liability for the attorney's fees incurred by the plaintiff who's prosecuting the case. The right to sue an insurance company can be assigned over to a restoration contractor. Not that we want to file lawsuits, but this provides very important leverage. In our case, Allstate tried to deny that the rights were assignable. And in part 2 of this series, I'm going to unpack all of that and tell you how we overcame it in order to recover more than 10 times the amount of the invoice. Stay tuned.